Welcome, everyone, to When Workers' Comp Meets Civil Court, Crossover Risks That Could Tank Your Case. I'm Michael Falati, and I'm the chair of the Workers' Compensation Law Section. I'm an attorney at Graywork Kaplan, Vernick & Evans, and I'm a certified specialist in workers' compensation law. Now, before I introduce today's speaker, I'd like to take a moment to plug the Workers' Comp section. The Workers' Comp section is a new and fast-growing section of the Beverly Hills Bar Association. I obviously encourage all workers' comp practitioners to join, but I also highly recommend that other practitioners in overlapping practices like PI and employment join as well. The amount of overlap I see in my own practice demonstrates to me just how much interplay there is between these practice areas. So it's worthwhile and perhaps incumbent upon our practitioners in these practice areas to familiarize themselves with workers' compensation, and vice versa, workers' comp attorneys should familiarize themselves with these overlapping practice areas. If, in fact, today's webinar, which is again about the crossover risks between workers' comp and civil court that could make or break a case, speaks precisely to that point. Should anyone wish to become more involved in the section beyond just webinars and networking events, I also encourage those interested in joining and taking on leadership positions and roles in the section. If you'd like to do so, please reach out to me or contact the Beverly Hills Bar Association Help Desk. We'll throw my email and the help desk email in the chat for anyone who wants to join and get more involved. And now I'm delighted to introduce today's speaker for today, Jonathan Roven. Jonathan Roven is a LA native and managing attorney at Jonny Law, where he focuses his practice on personal injury, employment, and workers' compensation litigation. He is licensed to practice in both state and federal courts in California and Nevada. A Loyola Law School graduate and Cali Award recipient, he has earned recognition as a super lawyer's rising star and has secured notable appellate victories for his clients, including successful outcomes in age and disability discrimination and workplace harassment cases. Beyond the courtroom, Jonathan serves as president of the Los Angeles Jewish Bar Association and is active in several plaintiff-side legal associations, reflecting his commitment to advocacy both professionally and within the community. And now let's get started.
Thank you so much, Michael. Thank you, Suzanne and Grace and the Beverly Hills Bar Association for having me. So today, well, just a little bit about me and why I wanted to give this talk is because it is so prevalent, the amount of issues that happen when there are both workers' compensation and civil litigation matters at play. And there are so many ways, so many pitfalls that can happen, but not just that, ways to maximize the amount or the recovery on these cases if these tools that I'm going to introduce get utilized. So without further ado, I'm going to share this presentation here. If it decides to share. Let's see if this is everyone able to see this?
It looks like it's actually on the other monitor, if there's a way to switch it. There we go.
All right. Okay, so this is great. Okay, so this is the talk when workers comp meets civil court, crossover risk that could tank your case. So got a little bit of a lag on these slides here. Why this matters. I want to start off with a situation where a $100 release could tank a $1 million employment case. So many times in the workers' compensation court system, when the workers' comp claims are about to resolve, they sign these agreements called compromises and releases. It's the workers' compensation version of a settlement agreement. What they will do is try to incorporate tiny release agreements within those workers' compensation settlements. And when there is an unsophisticated or someone who doesn't know how to recognize that kind of language, then that could severely impact a civil case. In terms of other types of cases like a wrongful termination or retaliation cases, in order to get the settlement, oftentimes the insurance or the defense will want the applicant, which is the plaintiff in the workers' compensation system, to sign what's called a letter of resignation. I hereby resign from my position as of this date, which can be used as evidence later on in a civil wrongful termination case to say, well, how could they have been terminated when they just signed this letter of resignation? So these are important topics, ones that come up quite often. And let's talk about the reasons why it's important for a civil lawyer to understand the workers' compensation system, at least from the bare minimum, so that they could avoid these types of situations. So not only is it important to know about the workers' compensation case because of mitigating those factors, but also to maximize the value of your civil case, because there's so much evidence that is available in these workers' compensation cases, such as medical treatment records, where the applicant is going to be sent to various doctors to get their treatments, where there's going to be potential witness statements, how certain accidents occurred, what was the investigation after the accident. There is potential investigation records and conclusions from those investigations by the company or the place where the person is injured. And there's also QME opinions. A QME, which we'll go into in a little bit, is a qualified medical evaluator, and it goes through a strike process where each side gets a strike from a selection of 3 panelists, and the remaining one becomes the QME. They're given many records to review, which arguably turns them into a retained expert, and then they render an opinion about the case and about whether the accident caused the injury. And this could be important especially in psychiatric, psychological cases. Second reason that it's important for civil lawyers to understand the workers' compensation system is, one, so that the claim doesn't get destroyed when it gets released on accident. 2, to prevent bad testimony when an applicant gives their deposition in the workers' compensation arena. And 3, to prevent a voluntary resignation, which can be disastrous in a termination case. So it's important to think of both of the cases as a single case, because the evidence is so intertwined, and the attorney that knows how to navigate both of those systems can really use it to their benefit. So the purpose of this talk is really to protect the client's civil claim, just outright, increase an overall recovery in both civil and workers' comp, and that the attorneys are able to coordinate a strategy to help each other in those kinds of cases. And so what we're going to do here is, first, I just want to emphasize what the crossover is. Second, to see what available options are there for each side helping each other, the workers' compensation attorney and the civil attorney, how they can help each other share evidence and coordinate how certain questions are going to be answered without causing damage to another side, avoiding settlement mistakes or inconsistent testimony, which could also severely damage either case. We're going to also talk about workers' compensation exclusivity, what it means, and whether a release in a workers' compensation case or the fact that it should an action may be brought in workers' compensation, does it prevent the person from bringing certain civil claims? And then finally, to discuss coordinating between the attorneys in how to maximize the recoveries for both cases. So I want to start off with talking about two parallel case lists, because the cases will go through timelines and the timelines may or may not intersect. So I have an infographic here on a workers' compensation case on the right and a civil employment case on the left, where this is, for example, a disability discrimination case where there's an injury and then the employer gets notified of the injury either through reporting the injury directly to the employer or filling out an initial workers' compensation form called a DWC-1, where that gets given to the employer. And from that point, now there is a potential case that is going to start in the civil, whereas the case has started already and will go usually at a much faster pace in the workers' compensation arena. So because it is going so fast, it's important that right when a person, an attorney retains a civil case, to investigate whether a workers' compensation case has already started, which usually it has, and to get in touch with that workers' compensation attorney right away to see where they are in the process. In the workers' compensation setting, usually the applicant is already getting treatment. They have already started the QME panel process to see when they are going to get evaluated and what records are going to go to the QME for evaluation. And they have already or are about to undergo a deposition in the workers' compensation arena. Depositions come very fast when it comes to workers' compensation. One, because they want to get the transcript to the QME for evaluation. But two, there's an attorney fee, the Labor Code 5710 fees that go to the applicant's attorney for submitting to the deposition, submitting their client to the deposition. So they tend to go pretty quickly. And the issue is that because they go so quickly, that there might not be adequate preparation from a civil perspective that could cause significant damage to a civil case. And we're going to go through what those what common mistakes or common testimonies are. So that's kind of the timeline that it's important to right away, once an employee or a litigant gets retained, to see whether there is the workers' compensation case going and get in touch with that counsel to see where it is. So here, this is actually a story from pretty recently where a workers' compensation attorney called and asked if I could look at a settlement document for them. And they said, I think they're trying to get him to sign a release for his civil claims. And we had already started representing this individual. So that's exactly what the insurance was trying to do, was settle out a claim when they had a pending civil claim for $100, and it later settled for well over $100,000. So it's significant, and they try and do this stuff. So we'll come into ways to prevent that. And so the cases will very often collide, meaning there's going to be the same documents that are getting exchanged from the defense to the applicant or the plaintiff side. It's going to be the same personnel records, but, maybe some type of difference in between them, but that's going to be important as well to see whether there is something missing in the civil case or something missing in the comp case. And those records might be quite valuable. There's going to be a deposition in both the workers' comp and the civil deposition, and it's very likely that both depositions will be carefully reviewed prior to trial to see if there's any sort of inconsistent testimonies. There's going to be experts in both sides, both retained and non-retained. Retained meaning that the expert receives records and testimony and undergoes conducts an evaluation of the injured. So they give informed opinions. And there's going to be settlement negotiations, different types of impairment ratings versus whether they have a disability. So there's a lot of crossover. And so I want to go over some of these workers' compensation documents, just so we have a fundamental understanding of what they are and how they can affect civil cases and vice versa. So this is called a DWC-1, and it's the initial document that starts the workers' compensation case. And what an employer is supposed to do, they don't do all the time, is give this document to the employee when there is information that the employee has sustained a workplace injury. And so the employee will put basic information, who they are, what their address is, and the date, time, and how the accident occurred that led to their workplace injury. And then the employer is supposed to fill out their information on the bottom, indicating who they are and who the insurance is. This is a very important document because oftentimes in the civil case, especially in the employment cases, the employer will claim that they were not aware of certain injuries, but this document will put them specifically on notice of what the injury was, even if there isn't much subsequent documentation directly between the employer and the employee, because after this point it goes to workers' compensation insurance, where many times the employer will claim they don't have knowledge. But this document here is given directly to the employer. And so there was a recent case that came down just a few weeks ago, actually, the Husband v. Target case, where they said, the Court of Appeal said that a company doesn't have to engage in an interactive process or accommodate when they don't know whether the individual has a disability or a suspicion of a disability. But a proper DWC-1 can completely change that argument and thwart any sort of lack of notice or lack of knowledge argument, because it says right there on the document what the injuries are and where it occurred and the date and the time, etc. And so this is another basic workers' compensation document that is useful in the civil arena, and this is called a PR2, and it is a primary treating physician progress report, and you also have the initial report, but this is the progress report. And specifically on the progress report, this gets transmitted either to the employer or to the insurance company. But importantly, on the second page of the document, it has a work status. And the work status is essentially a request for an accommodation or an invitation to engage in the interactive process, because it states this patient has been instructed to either not work or work on modified duty or work on a certain date, starting on a certain date without limitations or restrictions. And so this is an incredibly important document in civil cases because it shows what the requests for accommodation are and triggering the duty to engage in an interactive process, meaning the employer now has to talk to the employee to discuss what can we do to accommodate, can we accommodate, and if not, what are we going to do about it, and why can't we accommodate? And this document comes in various forms from different types of treaters. Here's one that was just pulled from online. This is a Kaiser work status report where it's just in a little bit of a different format, but they get sent straight to the employer, or if not to the employer, to the workers' comp insurance company, where they, adequate discovery could reveal correspondence between the insurance and the employer, where perhaps the employer is not doing what they're supposed to do, meaning they're not engaging in an interactive process or not even evaluating whether they can accommodate. So it's important to get that kind of data. And one of the easier routes to go is when there is regular communication between the civil lawyer and the workers' compensation lawyer. So for both sides, there's many discovery advantages when there is coordination between both attorneys. So let's talk about that briefly. First of all, in a workers' compensation case, there are often times that there is an investigation. And there's supposed to be an investigation when there's been a work safety issue, and certainly when there's an insurance claim involved. In an investigation, there's potentially witness statements from the employer. So that could be supervisors, coworkers, individuals that knew what happened subsequently. That could be incredibly valuable to the civil attorney before they take the actual depositions of these individuals, and vice versa. From the civil perspective, once they take these witness depositions, that's going to be incredibly valuable for the workers' compensation attorney. Perhaps they don't have that witness statement, or perhaps the witness statement and the deposition say two completely different things. Another another topic of documents or category is the personnel records, like I was talking about briefly before, is that there might be significant but important documents missing in a production in a civil case where they were produced in the workers' compensation case. And there could be many reasons for that. It could be a very limited view of looking at a request for production and saying, well, it doesn't respond to this request, but they could be quite significant, and it's helpful to have that coordination with the workers' comp attorney to get those documents. There may be different medical records. So, for example, if a person has what's called an accepted case in the workers' compensation arena, then they generally will treat within the insurance company's MPN or medical provider network. However, there may be treatments outside of that the applicant underwent over on the civil arena. For example, an out-of-network psychologist or psychiatrist that could benefit the workers' compensation attorney, meaning if they have a psych claim that is not accepted. So there's many different types of records that are going on and can help each other out. A big advantage on the workers' compensation side is that subpoenas are not costly for applicants and applicants' attorneys because it's supposed to be a no-cost system for applicants. Whereas in the civil arena, when there's many subpoenas going out to many different providers, the cost of obtaining all these records could easily run into the thousands of dollars, and depending on the budget for each case, that could eat away at a case's budget when they are already available on the workers' compensation side and may have already been retrieved. And so another advantage is when the documents get shared, compared, and but each attorney is able to use the data in order to help their clients along the way. And so this we were just talking about briefly is there's different types of documentation. The treating physician records, QME, AME. AME is an agreed medical evaluator when both sides agree on who is going to conduct the workers' compensation evaluation to assign certain ratings, which we'll go into briefly. Witness statements, as we talked about, from any investigations, and correspondence regarding any sort of accommodations, what the accommodation requests were, whether they could accommodate, whether they should accommodate, and what the interactive process, the discussion regarding those accommodations looked like. So briefly, I want to talk about depositions in both arenas. So in the workers' compensation arena, the applicant is taking the same oath when testifying that they do in the civil deposition. So anything they say in either one is going to be potential impeachment evidence. And if they're being asked the same question in each deposition and they're giving two different answers, then that could be very easy impeachment for the adversary. So because they are asking relatively related questions, it's important for the civil attorney to get in contact with the workers' compensation attorney, or vice versa. If the civil deposition occurred first, that the workers' compensation attorney reaches out to the civil attorney to see if there's a deposition, to prevent any sort of inconsistent testimony, because the consumers that we are representing are often not lawyers and have not gone to law school and have not gone through very significant education. And so they might not know the legal implications of answering differently in these scenarios, because in their mind, these are two completely different cases. And they may think that these cases don't have any sort of implication to each other, but too often they will give one answer in workers' comp to get benefits, to get better benefits, and give a different answer in a civil deposition to try and preserve that case. But the important fact is the best way to go about it is to discuss with the applicant and each other's and the attorneys on how they are going to strategize and give proper testimony that preserves both cases. So this is common damaging testimony in employment cases. The issue is that there is a conflict between damages in workers' compensation versus employment cases. So if an individual is unable to work in the workers' compensation system, that could be quite beneficial because that means that their disability rating may be higher or they may be entitled to more benefits because they were injured in the workplace. They might be entitled to more EDD since they are, quote, unable to work. However, that could be catastrophic in the employment case because one of the elements that employment attorneys have to meet is that the employee was able to work with or without reasonable accommodations. So there is a middle ground to meet, which we'll briefly discuss, that can preserve both the workers' compensation case and the civil case to maximize the recovery. So these are common examples. I'm on disability because I'm unable to work. I'm not looking for work because I'm hurt. Right. So I can't work because I'm hurt. These may or may not be entirely true. It might just be in their mind, the employee's mind, as to how they're supposed to approach the situation. But the better aspect is to figure out the right testimony, the more accurate testimony and specific to give to enhance both cases. And it's not just for employment cases, it's also in personal injury cases. Because workers' compensation is a no-fault system, meaning that the employee, the applicant, is likely to get compensated anyway, the testimony that they give in workers' compensation cases can be equally catastrophic in civil cases, meaning they wouldn't have an issue in the workers' compensation arena, potentially saying, I should have looked where I was going. I should have been more careful. I knew the bump was there all the time, or I should have watched where I was going when running through the street light, etc. And that could destroy negligence cause of action to say this person is entirely at fault or there's too much comparative negligence here. So for PI attorneys, it's also very important to coordinate with the Workers' Compensation Council to see how that what kind of testimony is coming out, how they're answering questions, and perhaps to give more accurate and descriptive answers to questions to preserve both cases. So in the employment case, if a person says, I'm unable to work, that is quite a drastic statement. If they are truly unable to work, then yeah, that's going to be the testimony. But if they are unable to work within their restrictions without a reasonable accommodation, that would be one, more accurate testimony, and two, that's going to preserve both cases. Because if the employer cannot accommodate, then that's going to assist the workers' compensation case in maximizing recovery. And if the employer is unwilling to accommodate, that's going to assist the employment litigation aspect. So it's better to give more accurate testimony, meaning usually when a person says, I can't work, it's usually because it's without a reasonable accommodation, because someone can do something. They could do light duty, they could do desk work, they could do part-time work, they could do minimal work. It just depends on what the accommodation is. So it's better to give more accurate, descriptive testimony. And also in personal injury cases, perhaps they don't say, I should have looked where I was going. I should have been more careful, like blaming themselves. Because if they did look and they were reasonable about the situation, the person might not deserve to have comparative negligence on them. So they need to give more accurate testimony in terms of these kinds of cases. And that's why it's important to coordinate. And so when there is coordination, there needs to be, phone calls, perhaps a joint meeting where the topics that are going to be addressed in the cases and especially in depositions are going to the attorneys would go over them and see how they would answer in certain situations. I've heard many times of employees in workers' compensation cases simply say, I can't work, I'm not looking for work, I don't want to look for work, which could destroy both a failure to reasonably accommodate cause of action and also a mitigation of damages, because the employee, if they've been terminated, they have the obligation to mitigate their damages, usually by looking for work. And they could look for work within their restriction. Even if they get denied the application, they're still looking for work. So it's quite important to have that meeting. And if the meeting isn't had, to at least discuss with the client the potential pitfalls and how to answer questions more accurately so that they are less damaging to either case. But the ideal way is to have the discussion with the other counsel. So many sample deposition questions that can be asked and that are asked in both arenas. What work are you unable to perform? Can you perform your job without restrictions? What are you unable to do? Are you totally disabled? Are you disabled? I mean, these are highly significant questions in employment cases, in personal injury cases, and in the workers' compensation cases, and they may have completely different implications in each case. So they're important topics to go over. So I want to touch upon the medical evidence that gets created in the workers' compensation arena versus the civil arena. And the most significant crossover, I would say, would be the psychological, psychiatric records, because they both have to do with the emotional distress, pain and suffering damages that give rise to a significant portion of the damages in employment cases, especially in wrongful termination, retaliation cases. And so by an employment attorney getting these records from the workers' compensation attorney or having that discussion, that could be quite significant in supporting the employment claim for the pain and suffering damages. And what's even more significant is that the QME reports, they show that these are much more neutral reports. So an insurance or a defense would have a difficult time arguing that the attorney sent the client over to this doctor, meaning the doctor has some sort of bias when it's a QME, because it goes through a strike process. So we once had actually this is a fairly common fact pattern where the employee is reluctant to get treatment or has difficulty getting treatment. They don't have insurance and they might be unreliable or just having difficulty in getting the proper treatments for the civil arena. But even with just a good QME report and deposing the QME for preparation for a civil trial, that could be quite advantageous for civil cases. And so we had a situation where it was very difficult to get a client into proper treatment. We just had, one report from a treater, an initial treater, and a QME report, and it was able to resolve for in the 7 figures. So it can be quite significant. So going to briefly touch on some terms that are important to know. So the QME, AME reports we spoke about, in those reports, there's going to be usually a discussion on whether an applicant or the worker is what they call temporarily totally disabled, which in the workers' comp arena means one thing, but in the civil arena may mean something totally different, meaning completely unable to work when that might not be the case. It could mean that they can't work within the restrictions. And then there's permanently totally disabled and permanent disability. However, it's important for a civil attorney not to take these terms at face value, meaning just looking at the term and saying, oh, I think I know what it means, and that doesn't sound good, because there could be a significant value in further investigating to seeing whether that it is a total disability or whether they are completely unable to perform the essential functions of their duties. One of the reasons why this is, when it's in 2 different systems, it means completely 2 different things, is that in the workers' comp arena, they go through a rating system, meaning that there's numbers, letters, and what they call strings to evaluate what the value of the case is or what the value of the disability is. But so when it says permanent disability, that doesn't necessarily mean that a person is permanently disabled. That just means that they have or they may have some sort of impairment. It could be to a foot or a hand or a nervous system or a stress system. But it doesn't mean that they're unable to perform their job duties. So these terms are not to be used interchangeably, but when looked further into it, could provide valuable information to enhance both cases. And so here we say permanent disability does not mean a FIHA disability, and it does not necessarily mean that a person is disabled. Another portion of the QME or AME reports is that they have a section called apportionment, meaning did the accident cause the injury? And when it comes to emotional distress or pain and suffering damages, non-economic damages in the civil case, this opinion in a QME, in a psychological or psychiatric QME, can be quite significant because the QME or AME will likely be looking at alternative stressors, meaning how much stress was from the personnel action versus how much stress was from other pre-existing or post-existing events. So it's quite important to look at the QME opinion to see what they have to say about it. and what evidence they relied upon or didn't rely upon. But in many situations, it can be incredibly valuable because a QME may say, I believe that, 90 or 100% of their current psychiatric, psychological state is due to this bad faith personnel event. So when you have a report like that, then you can use it as leverage in your civil case. And so even though there's crossovers, there's also evidentiary limitations, meaning in the workers' comp arena, it's acceptable and customary to just walk into court with a medical report and toss it in as an exhibit, and the court accepts it as the exhibit. That has many preventions, obstacles in a civil court. The doctor needs to get deposed. The information that they relied upon in order to formulate their opinion might not be admissible evidence. So it's important to understand the differences there, but also where to look for the right evidence. And so this is probably the most important topic, is the settlement landmines. And we're going to talk about the compromise and release, which is the main settlement document in the workers' compensation arena. And it has basic information, demographics, who the attorneys are, who the insurance is, how the injury happened, whether certain medical benefits were paid for, and what the body parts were. But very importantly, and this is probably the most important sentence in a CNR for a civil attorney, is buried at the end of this paragraph, which says that execution of this form has no effect on claims that are not within the scope of the workers' compensation law, or claims that are not subject to the exclusivity provisions of the workers' compensation law, unless otherwise expressly stated. And so that is the aspect, that's the most important part, is that unless otherwise expressly stated, meaning that a person can and often do waive valuable civil claims in the workers' compensation cases. And this is the signature page. So the seminal case on this topic is called Claxton v. Waters. And so it basically says that the standard compromise and release, the standard form, unless there's something extra to it, it can't be used to waive civil claims. And that's important, meaning an attorney, both civil and workers' comp, should look at the CNR to see if there's any hidden language to try and get rid of the civil claim. So many times there is an addendum to the CNR, addendum A, and that will be just a formal release. Could be extra consideration. On Section 8 of the CNR, they'll put a lot of language as to the basis of the CNR, and they also may include a tiny little section about any and all claims. And that could damage the civil case. That could release the civil case. And there's also a comment section where they may include the release of civil claims or claims in other jurisdictions. So those are usually the three areas that I've seen release attempts. So there's prevention. There's ways to prevent the attorney from accidentally having their client waive valuable rights without knowing. And one way is discussing with the client, you're going to receive a workers' compensation settlement, but I want to take a look at the document to see whether they're trying to release the civil case. A second way is to just put language in there, and I've included language here that I've used many times in the past, essentially saying that this workers' compensation claim has nothing to do with the civil claim. And a third is obviously to look at the CNR and strike out the language where they are trying to release the civil claim. So another settlement landmine or pitfall is the voluntary resignation, which is very common in nearly all workers' compensation cases. At the end of the case, when they are about to settle it, the insurance wants a letter of resignation from the client, from the worker, saying, I hereby resign from my position at the company. That could be destructive to a wrongful termination case, where in the civil arena, the employee says, they fired me, and then they get confronted with a document that they signed in the workers' compensation system saying that they resigned. And that could be quite insignificant. So what do? Instead of resigning, what I've used in many circumstances, pretty much all of them, unless there is no wrongful termination case, is what I call an acknowledgement of separation, meaning that the employee acknowledges that they are no longer employed with the employer. In that way, it will preserve any civil claim, because all they're saying is that they don't work there anymore. They're not saying what the reasons are. And that usually suffices the employer's concerns. And so also on the civil side, when settling civil claims, the defense or the insurance may try to include claims that will harm or pressure applicants in workers' compensation cases to settle or dismiss their claims. So, for example, there may not be a workers' compensation carve-out saying that this has nothing to do with workers' comp. And so perhaps a defense attorney would try and say, well, look, they settled their civil claim, and so we're entitled to, a credit, or this has already been resolved because they resolved it for their injuries. If you look at those release paragraphs, there's many, many things listed in there, including physical injuries, mental injuries. And so if a person is releasing those in the civil arena, and it's not supposed to be like that, the workers' comp might try and pressure resolution in that arena. There's also language where an employee will sign that they were not injured in the workplace. Those are those are minor terms, like, people may just peruse or not read the settlement agreements carefully, but it's common that a defense attorney will put in the agreement that the employee agrees and acknowledges that they didn't suffer an injury. They could be waiving 132A rights, perhaps, and that's the retaliation for the filing of a workers' compensation claim. Perhaps there could be an ongoing claim in the workers' compensation arena that just got waived in the civil arena. And another common term is to request a dismissal of any current claims and that they verify that there are no other pending current claims. So it's important for the workers' compensation attorney to look at the civil settlement document to make sure that their workers' compensation case is not getting adversely affected. So those are the important topics there. And then I'm going to briefly touch on exclusivity. What does it mean that an injured worker, when they're injured on the job, then workers' compensation is their only remedy and they can't go after the employer outside of that jurisdiction. That's essentially what the rule says. However, there's exceptions to the rule, and the main exception is whether the conduct was outside of the compensation bargain, meaning was it by the wrongful conduct of the employer. And so the main inquiry as to whether it applies, whether the exclusivity rule applies, which is an affirmative defense in almost every answer, especially in disability discrimination cases, is why is the employer being sued? Are they being sued because the employee got hurt, or are they being sued for the unlawful conduct that ensued, either giving rise to the injury or subsequent to the injury? So if it's because of the injury, then it's usually going to be exclusivity. However, there's many claims that do not fall within exclusivity, and those are usually the FEHA claims and a wrongful termination claim, because that is outside the bargain. And also for car accident claims, that the two cases can be proceeding at the same time. So even though a person was working and gets injured by a third party, technically they were working. Perhaps they are doing deliveries or purchasing work materials. Still, they have the ability to go to have their third party claim, and that would be outside of the bargain, obviously. And so we're just coming up to the hour, and I just want to finish here. So we're going to talk about returning to work. And this is where many of the civil cases get created, where the employee gets injured and there is quite insignificant communications between the employee and the employer to discuss returning to work. Every employer with 5 or more employees has a duty to engage in the interactive process in California. They have to discuss how are we going to accommodate you? Can we accommodate you? As the employee is discussing that, if they're only represented by workers' compensation counsel that does not have experience in the employment arena, they might not recognize the pitfalls or the creations of civil claims in that discussion. And that's a discussion that takes place in a vast majority of workers' compensation claims. And many times the employer just says, no, we can't accommodate. There hasn't been a timely or good faith inquiry. And so when there is a request and a denial, that's essentially the creation of a civil case, or at least a civil inquiry. Going to touch upon these ethical considerations is that if an employer is represented in a civil case, then it could be complicated as to how the attorney is going to discuss with the employee, how to discuss with the employer. So that takes looking into and seeing how that goes about. But both parties, including the employee and the employer, have to talk to each other. So if the employee goes to get advice, it's not exactly the attorney telling the employee what to tell the employer, but the advice that the employee gets in order to engage in the interactive process, was since they have a duty to do that. Because the liability when it comes to the interactive process, it usually falls on the party that causes the process to break down. So the employee needs to engage and discuss with the employer about potential accommodations. And so it's important to coordinate with the workers' comp who had just received this PR2 report, and it gets sent to the employer, and they're trying to see whether they can accommodate. And they might get a frantic phone call from the applicant saying, my work isn't accommodating me, and they said that they can't have me work there anymore. What do I do now? Which is a common theme in workers' compensation. And so it's important to make sure you're getting all the bits of information, the emails that go back and forth, etc. So I'm going to go through some best practices in these cases is to communicate early. If you find out that there is civil counsel or there is workers' compensation counsel, introduce yourself, share major events. I'm about to have this deposition of my client on this day. Is there anything that you have concerns about? Let's talk about the major issues in our cases. Exchange documents, and before the client signs off on an agreement in either arena, that the other attorney should look at the agreement to make sure that it's clean. And so these are the main places to discuss. Would be at the time of the complaint, the intake, the discovery, settlement, depositions, and trial. In the civil side, these are some documents that are usually useful and available from the workers' compensation side, which will be the claim file, the records and AME, QME reports, depot transcripts, the PR2s, and settlement documents, obviously. And vice versa, for the workers' compensation attorney, there's quite significant documentation, which could be the deposition transcripts of individuals that they might not have witness statements from, the employment discovery, answers to interrogatories, where those might be answered differently than what is stated in the evidence, and other expert reports. Perhaps there's a defense expert report, and so which could be used in the workers' compensation arena. And so finally, to conclude, I listed the top 10 mistakes: not coordinating with the counsel, not preparing for the deposition, not looking at the discovery, not reviewing a CNR, voluntarily resigning, giving inconsistent answers depending on the arena, taking inconsistent positions on whether they can work, etc. Overlooking return to work communications, that's the interactive process. Not understanding whether the actions are not to be exclusive within the workers' compensation arena. Not adequately reviewing the medical opinions and treating the cases ultimately as separate cases when they both are affecting each other. And so finally, what I would recommend is coordinating early, sharing information, leveraging each other's file, preparing for each deposition, reviewing the settlement documents to make sure you're not waiving your client's claims in the other arena, and to not think of it as two cases, but as one case, just in two different forums. And so thank you so much. Just one final tip where you can also handle them simultaneously yourself if you come to learn both the arenas, and those can be quite significant. And I was talking about the case earlier where we handle both at the same time, make sure all the answers are consistent, and at least in this situation, resulted in seven-figure resolution. And so these can be quite valuable to you. And that's it. Thank you so much. So I wanted to open it up for any questions.
All right, Jonathan, it looks like we have two questions for now. One from Judith Coker. Regarding the language that this release does not include civil claims, if you add it to the document, it seems that it would need that to be initialized or initialed by all parties, which defendants may resist. Do you agree?
Yeah, so you can, if you are putting into the CNR that that it's not going to affect a civil claim, I mean, the defense is already going to sign the document, and if they are intending to settle the civil claim, then that's going to be something that needs to be discussed with the client, because there's really no reason why to try and settle a civil claim or demand that kind of language when they're not trying to settle the civil claim. And did you say there was one other question?
Yes. Can you comment on how to avoid exclusivity issues where a FIHA client seeks emotional distress damages for the harassment and/or discrimination through workers' comp?
Yeah, so that is a topic that gets brought up quite often. And the important factor is to determine where the emotional distress arises from. So if it arises due to the person having the physical injury, then that is going to be subject to the exclusivity. But if a person is terminated and that is where their emotional distress arises from, then that would not be subject to the exclusivity. So it's important when preparing the client for depositions is to have them adequately discuss, from a civil perspective, how what the pain and suffering symptoms are due to the failure to accommodate. I thought that my employer was going to be loyal to me because I was loyal to them, or how the termination has impacted them emotionally, how not having a job due to the wrongful termination has impacted them emotionally. And so that is what usually preserves a person's ability to pursue the civil claim without getting hit with the workers' compensation exclusivity.
All right, Jonathan, it looks like we actually just got two more. Do you have the time to answer
Sure.
these? All right. All right. So one of them, how do I get depositions paid for by the insurance carrier in a workers' comp claim if it is a non-medical deposition but material to acceptance or denial of a workers' comp case?
Well, if it is the applicant, then you would write the letter to the insurance company. But I believe there's usually a petition that can get filed, but that's kind of beyond the scope of the presentation. But I believe there's a petition that needs to get filed after a meet and confer effort. And then if that isn't able to get resolved, then to file the declaration of readiness to proceed to get the hearing and go that route.
All right. Last question. Thank you. One more. How do you obtain work comp file if client or PC doesn't have a work comp attorney?
Yes, you can subpoena the insurance company, the workers' compensation insurance company, and ask for relevant data. So that could be correspondence between them and your client, which is not going to be protected, or them and the employer, which may be protected. What the investigation was that they conducted, what medical records they received, what medical records they sent off to the employer. There's a list of categories, so that would be the right way to go about it, is to just send a subpoena to the workers' compensation carrier.
All right. So it looks like we just got one more. Would you like to hear it?
Sure.
All right, so one more, going back to the question regarding exclusivity issues in a FEHA matter, would physical manifestations of emotional distress, for example, headaches, fall under exclusivity?
I don't believe so. And actually that is so you have to go to the root of the problem, which is the physical manifestations of the stress was the stress from the wrongful termination. Then all the residual effects, or the sequela, as they say in the medical world, would that points to the wrongful termination. So if they didn't have the wrongful termination, or if they didn't have the violation of the FIA statute, then they would not have had the physical manifestations, and that would even be more corroborating to the pain and suffering damages in the civil case.
Alrighty, that's it for questions today. This concludes today's presentation. Thank you so much, Jonathan, for taking the time to answer questions and for educating our members. And thank you so much to our audience for joining us today. Have a great day, everybody.
Thank you.